Welcome everyone, and thank you for joining us today for our webinar on Peacemaking 2. My name is Rebecca Horse-Chief. I'm Osage from Oklahoma, and I am the Program Coordinator for the National American Indian Court Judges Association. I'll be moderating today. We want this to be as interactive as possible, so please feel free to ask questions throughout and to make use of the chat feature that Jessica mentioned. And with that, I will hand it over to Dr. Watts.
Thank you, Rebecca. I'd love to be a doctor. Unfortunately, I just have a JD, so don't get to be called doctor, but that's okay. So welcome, everyone. Thank you for joining us. Let me apologize in advance. I taught a 4.5-hour class in a big auditorium last night, and they didn't have a microphone, so I was trying to yell for the folks in back. My voice is a little shot, and I may do a little coughing, and I apologize in advance for that. So I am Sean Watts. I'm a professor at KU, Kansas University School of Law, where I teach mediation and help run the Tribal Law and Governance Center, in addition to other kind of lawyering classes, legal writing, and so forth. So this is a part 2, and what that means is that we're going to do just a little bit of review for folks who are coming to this from having gone through it last time, but may need to just a little review to catch up. And also for folks who weren't able to join us last time, so we're not leaving you totally behind, but the goal here is to really move forward a little bit. So we're going to introduce and review the United Nations Declaration on the Rights of Indigenous People, especially because part of what we're here to talk about is the way tribes can resolve disputes amongst themselves, and using that declaration as a context. Also give just a brief background on peacemaking so we can go talk more deeply about its theory and its practice, really get into some of the mechanics, looking at a really close look at the process, and then biasly give what I think are the many advantages that peacemaking has over a regular court model, especially for tribes looking to integrate some of their own traditional practices. So what is the UNDRIP? That's the acronym for the United Nations Declaration on the Rights of Indigenous People. It was actually a pretty landmark declaration that the UN put together after spending years in different versions of trying to go through it and make something happen. It was where the United Nations as a body declares the collective and individual rights of indigenous people. So kind of the first time the UN really makes an effort to say that not only do indigenous people exist, but they have a right to exist, and they have a right to exist, importantly, as indigenous people. So not just integrating them into the scheme of the United Nations, but really honoring and respecting their integrity as nations. As you look through it, it contains lots and lots of really interesting pieces, but for our purposes today, since what we're really here to talk about is dispute resolution, I'm going to talk about Article 40, because that's the one that really comments on the way disputes might be resolved. So it notes that if there is a dispute between an indigenous people and a particular nation state or any kind of other parties, including business parties, those sorts of things, Article 40 says that indigenous nations should have, or the people in those nations should have, access to prompt decisions. So when there's a dispute, when there's something going awry, we should be able to get some sort of decision on what our issue is right away through a fair process. So they're supposed to provide remedies for infringement, not just on the any individual's rights, but the collective rights. So really recognizing indigenous nations as a collective. And one of the things that they take some time to make and to note especially are indigenous customs, their traditions, and especially the legal system. So that's the idea that we may have our own ways of processing law or administering justice. Because what we're dealing with in this case is the United Nations, it is, as some of you may have had experience working with them, it's a body that moves at a rather slow pace. It's a body that works off of protocol, and it's very deliberative. And because of that, there's not a lot of facility there in getting things done, but we're going to talk about some of the realities that come with the UNDRIP. So one is there's not, in the UNDRIP, not a clear means of enforcement for the signatory states. So last time we talked about who had signed it, and it was everyone except for the big four who you would expect, which were the countries who had had some real historical problems with abuses and atrocities towards their indigenous people, so U.S., Canada, Australia, New Zealand. Those folks have all come on board now, so it's basically completely signed. Still, not a clear means of enforcement. There's not a clear means of a forum, so in other kinds of UN either declarations or other treaties, there will be some sort of forum to address, like there are different courts for certain things. They didn't build that into the UNDRIP, which means that we're still processing how to get through it should a complaint arise. And there's not really a requirement that any of those signatory nations implement it in any meaningful way. For indigenous nations, there's nothing, though, that prevents us as our own individual autonomous collectives to adopt the UNDRIP in whole, so just incorporating the text, or if we want, we could just adopt parts of it. There's certainly nothing that prevents the indigenous nations from banding together on cooperating and trying to adopt this writ large. So those are some things that can be done with it. Interestingly, we've got Judge Greg Bigler, who is out of Muskogee in Oklahoma, who has really tried to put together a group of people who want to spend time thinking about this. So he's been really inclusive in what he's done. So he's got judges, he's got tribal leaders, he's got academics, he's got folks who are sort of more on the business side for tribes, lawyers, all that sort of thing, really, really looking towards how we can use UNDRIP as either as a backbone or a backstop for things that we want to do to advance what's going on in Indian country. And more broadly, he's starting to think about just the future of Indian country in general, spurred by his own thoughts about what's going on, but also, of course, the election, our most recent presidential election, has played into that as well. So if you are interested or sort of want to participate or just more broadly want to understand more, Judge Gregory Bigler is someone you can look up. He is, again, from Muskogee Nation in Oklahoma, and you can find him on the website there. You can find his email. The United Nations is getting a little more interested in upholding UNDRIP and trying to do more with it, and one of the things that's happening now is I'm working with a couple of different missions on implementing or developing and then implementing a much broader educational program on indigenous issues, something that I've done in the past. I've done work with the UN as a whole and specific missions on different conflict resolution trainings and education. But through that, some of the folks from some of the countries where they have a large group of indigenous people really want to focus on that. And so we're trying to develop that now. My hope is that it's something that would be interesting to people and it's something that we can get into the ground within the next year or so. Okay, so we're going to shift from the UNDRIP, which is something that might provide a context for us to start thinking about dispute resolution, and into specifically peacemaking. So what is peacemaking? It is a traditional form of dispute resolution practiced among tribes in this country and frankly many other countries for time immemorial. So we don't really have a begin date, and as because of the work we're all trying to do together, hopefully there's not an end date on that as well. It is a generic term, and by that what I mean is for people my age, and I would guess many people on the call, if we need to blow our nose, instead of saying I'm going to get a tissue, which is what the young folks say these days, we say I'm going to get a Kleenex, or I remember making photocopies, and instead of saying I'm going to make a photocopy, I'm going to make a Xerox. Peacemaking is that sort of, it's that sort of brand name, in that the tribes who have peacemaking may call their program, and are likely to call their program, or encouraged to call their program, something that is comes from the tribe, it comes from the tribe language. Peacemaking, I believe, is a translation of a Navajo word, and because the Navajo really got it going again big in the 1980s, they sort of are the first in, and so that's the word we use. It was lost in the 1880s, and I put lost quotes around lost because obviously it's not gone, certainly not forgotten. It's in use, but there were some things that happened in the U.S. that made it so that it wasn't able to be used as it was to the effectiveness it was in the past, and we're going to talk about what that is right now. So there were policies that the U.S. has employed over time to obviously affect and diminish the capacity of tribes in this country, and some of those policies were targeted specifically at tribal dispute resolution. There are different periods of time in the course of U.S. history where the federal government had specific policy slants and how they were going to deal with tribes. And I'm going to talk about specifically about the reservation period. As most of you probably know, there was a time when the federal government tried to basically corral tribes onto certain areas of land, define some boundaries, and hoping to keep the tribes within those bounds. And part of what went along with that was putting Indian agents on the reservations to oversee, and then a few other things that happened. One of the things that happened that was important is the case of Crow Dog, which happened in the early 1880s. That was where we had the principal medicine person for a tribe and the principal chief involved in a conflict where the principal medicine person shot and killed the chief. The tribe deals with that in the way that the tribe is accustomed to, according to their traditions and according to their customs. They dispatch peacemakers to the families. They go through a long process where they're using tribal law, tribal custom, tribal tradition, using tribal dispute resolution, and come to a resolution where, amongst other things, it's determined that Crow Dog has to take care of the principal chief's family for the rest of his life. So someone there to be responsible for that family who has lost a very, very valuable member to them. Well, this happens in South Dakota. South Dakota, as a state government gets wind of this, decides that doesn't comport with their version of justice, which is retributive, the kind of thing where we're trying to just get back at somebody. And they send police to arrest Crow Dog, which they do, put him on trial, convict him, sentence him to death. Someone files a habeas petition at the federal level. The case goes all the way up to the Supreme Court, and here's where the Supreme Court says the murder of one Indian by another Indian inside of Indian country was solely within the jurisdiction of the tribe. So we had a ruling on that earlier in the Cherokee cases where the state jurisdiction on tribal land is done away with, but this is more specific. So it's dealing with this crime specifically, and the federal or the Supreme Court is clear: states have to keep their hands off. They don't have any jurisdiction over tribal land. However, Congress gets wind of that and decides at a federal level this idea of peacemaking, this idea of tribal dispute resolution, doesn't comport with their idea of retributive justice either. And so they pass something called the Major Crimes Act. And what the Major Crimes Act does is, in a very short piece of text, it enumerates certain crimes that they designate as major, and it's the kinds of the crimes that we would think of as major crimes, where they say anytime these tribes occur that on Indian land by Indians, instead of it being the tribe's jurisdiction, it becomes solely the jurisdiction of the federal government. So the states are still out of it, but instead of the tribes being able to deal with these problems or these disputes or these harms, the federal government gets to take control of that. And so what that means is some of the most major conflicts, some of the most major harms, some of the things that are going to matter most to tribes and how that resolution comes about, instead of getting to be decided by tribes themselves, now it falls under the purview of the federal government. So they remove the ability for tribes to really address their most egregious harms. And that brings us to the U.S. justice system. So now we have some of these major disputes or major conflicts, major harms being handled by the federal government. So it's important to take a look at what the federal government does. What is the goal of the U.S. justice system? So they have deterrence. It's a weird theory, deterrence, which is that if you craft or create laws in such a way that they're scary enough or where the punishment is harsh enough, that'll prevent people from doing a bad thing, committing a crime in the first place. And so one of the things that it's important to look at under deterrence is the idea of whether or not it's actually working. So in the United States, we've got almost 22, oh sorry, not 22. We've got 2,200,000 people incarcerated in the U.S. It's about 737 per 100,000. At an occupancy of 107.6%, what that means is we have capacity for a certain number of people, and we have exceeded that capacity pretty greatly. As you're thinking about the idea of deterrence, that 2 million prisoners, 2,200,000 prisoners, would be, if you put it on a scale of our largest cities, would be our 5th largest city. So not quite as big as Chicago, but a little bigger than Houston, and more than any other country in the world. So we've got 4.4% of the global population. So if you take everyone on the earth, the United States has 4.4% of the population. And at the same time, we have 22% of the prison population. So both by percentage and by sheer volume, we've got more prisoners than China. We've got more prisoners than Russia. So we're doing a good job at putting people in jail. Another goal of the U.S. justice system is incapacitation. So that's the idea, okay, so maybe deterrence didn't work. What we will do then is incarcerate people to try to reduce or diminish their capacity to commit other crimes. So incapacitate them, make it so that they can't do anything, doing the bad things anymore. So the problem with that is once you get people in jail and you start to put them together, you end up with, because of the quarters we put them in, we end up with crimes, a significant number of crimes from inmate to inmate, so, and violent crimes as well, on top of the fact that you have crimes coming from the inside out. So you have gangs and other kinds of very well organized, very well run criminal operations operating with kind of within the safety of a prison, and that crime traveling outside. They don't really keep statistics on this because that's not something they want anyone knowing about. Okay, so let's say deterrence didn't work, so the person goes to jail. We get them in jail. They're supposed to be incapacitated. While they're in there, the idea is that we would rehabilitate them. So while we got them in this as a captive audience, the idea would be that we would find ways to make them better, to make them come around to getting rid of their old bad ways and coming to new, better ways. So how is rehabilitation working? Not so well, as it turns out. So, sorry, this went out of order. So within 3 years of release, folks who have been incarcerated are rearrested at a rate of about 68%. So just after getting out of jail for 3 years, they're back in within just a short bit, within 3 years. Within 5 years, the rate jumps up to about 77%. So at this point, we're talking 3 out of every 4 people who are released end up back in jail, so not rehabilitated. And the crazy thing is, of those that do get rearrested, more than half of them happen within the first year. So whatever we're doing with rehabilitation isn't working. The folks who are coming out are going right back in. Some of that is because when we're talking about rehabilitation in this country, we're not putting money into it. We're not putting programmatic design into it. We're just not doing much to make it happen, so not really a goal. Then, of course, there's retribution, which is, if we think back to the Crow Dog case we talked about just a few minutes ago, retribution is really where it's at in this country. The idea that when someone in this country commits a crime, the idea is to really just punish them. And so that's where we really excel. And the problem is that there's a long-term after effect of punishment, and we can talk about those as we move forward. So that was the goals of the U.S. justice system, and then a little bit of how it's performing and accomplishing those goals. We're going to talk now about goals in peacemaking. You'll see these are pretty starkly contrasting to the goals of the U.S. justice system. So one is peacemaking is designed to restore relationships among the people. So not just deal with the issue, but help restore, help bring to wellness, help cure some of the underlying relationship problems among people to help bring a community back together. So in trying to restore relationships, they explore the very nature of the feelings, the issues, and the interests that are some of the problem and that can help be a solution to getting us out of the problem we're in the first place. The goal is healing and transformation. So not the idea that we just convince a person not to do something bad again, but really heal the human who's gone through the trauma of needing to do something bad or been affected by having someone else having some sort of crime or some other offense committed against them. So healing those people and then transforming them so that they become a true part of the community again, healing not just the individuals, but the community itself. And then the idea is to close the circle. So if we can heal the people, involved, that we can close the circle instead of having a broken circle with someone outside of the circle. Another thing that peacemaking strives to do is help people reconnect to their culture. And so some of that happens by using generational participation. So most of the time, as you probably have seen, either in court yourselves or just even kind of watching movies, when something goes on in a courtroom, normally it's the lawyers, the accused, or if two people are suing one another, the lawyer, the complainant, the defendant, and the judge. And that's really the extent of the participation except for potential witnesses. But in peacemaking, it involves more than just the people who are involved in the conflict. You're looking at involving people who are important to the people involved in the conflict. So you might have, if a mother and a father are in conflict, you might have the children involved, so one generation down. Or you might have the mother and father's brothers and sisters, so aunts and uncles to the children involved, or even aunts and uncles to the mother and father, including grandparents. So getting multi-generational participation, really thinking about bringing a whole family together and a community together because of it to reconnect to their culture. There's an emphasis on a shared history, and it's one of the major advantages that peacemaking has that other forms of dispute resolution don't have, is that you're able to both fall back on and really use the relationship that the people have had together, a shared history, not just among them as a family or as individuals, but ancestrally. So you can go way back, really reconnect to the culture, remind people who they are. Another goal of peacemaking is to respect tradition. And so under that, we're talking about using traditional ceremonies throughout the process, not just to begin, not just to end the process, but really anytime you can use traditional ceremonies, traditional practices to, again, help ground people, to help respect their tradition, to remind them that they're part of something bigger. And tribal languages get used where possible, which is something that I think is happening more and more these days, which is you can operate some of these peacemaking circles in the traditional language of the tribe. And that's really only going to get more prevalent in the future. Some tribes have started to create and really have thriving language schools, so language immersion schools, where the children of the tribe are now going to schools where the target language in the school isn't English or anything else, but is the language of the tribe. So this is only going to become something that's used more frequently, which means it's only going to help the process thrive even better. Of course, another thing that peacemaking wants to do is retain values. And so with the idea that values are what drives the process. So they are what makes the process important in substance, the things that we actually talk about, the way we're conducting ourselves, and then the procedure itself for the process, something that we use to make sure that we are all along the way retaining who we are as people in practice. Okay, so we've gone through a little bit of what its goals are. And I hope that's a review for some folks who were with us last time and maybe catches up some folks who are with us for the first time. So now we're going to talk about the process itself. So hopefully you'll have some sort of traditional opening and closing and really other things along the way. So that can include prayer, that can include other kinds of ceremonies to mark the beginning of a day, to respect the nature around you, any number of things like that. And we're not talking about just any single process. It may be that there are lots of different traditional ceremonies that make sense to use both through custom and tradition and to actually enhance and mark the peacemaking process itself. So in that you might have some prayer, some purification. Once the circle gets going, most folks will be using something called a talking piece. And a talking piece can be most anything, honestly. It's again, one of my favorite things about peacemaking, one of the things I remind anyone that I'm working with is that you are really only limited by custom, tradition, and your imagination. So as long as you're respecting custom and tradition, you should really be thinking about designing a process that's going to be the most valuable to you as a people on the whole and as individuals in the circle. And so that talking piece is something that is chosen to designate who will be able to speak at a particular time in a peacemaking circle. So whoever's holding the talking piece gets to be the person who's talking. That can be chosen by the tribe, so it could be something that's just important as a tribal piece that we know people will respect and that we know people will honor as they're holding it, and they'll give their all in what they're saying, and they will sit and listen to other people who are holding it to talk. It could also be something that's chosen by the participants, and one of the beautiful things about peacemaking is as you're designing your program, you want to check with custom and tradition to see if there's something that you can or should be using. And then also if there's any allowance to let the participants choose what that peacemaking circle's talking piece is going to be. The movement of the talking piece can occur in a few different ways. Again, you should really look to custom and tradition to see what that movement's going to look like. But just a few of the ways it could move might look like this. One is just where you have people in a circle and you just continue to pass the piece one by one to the left or the right, depending on what works with custom and tradition, where the rotation is sort of forced. So it just goes in a circle, and once you've passed it, you know you're waiting for the whole circle to come back to you. Another way is to have the peacemakers give the talking piece to whomever they think the appropriate person to speak in the moment is. And another way is to put the talking piece in the center of the circle and just allow whomever feels good about coming in, getting the talking piece and using it to speak in that particular moment is. And then, of course, you can do a hybrid of any of those. You could use some of those motions sometimes. So I will probably continue to say this at almost every turn, but one thing that you should always do is make sure as you're thinking about how these things are going to work, always consult custom and tradition. You want to honor your tribe's custom and tradition first, and then once you've made sure to do that, you have some leeway in how you might design how things would work outside of that. In the process, there's always going to be a discussion of values, and we're talking about different kinds of values. So you have culturally based values, which again are relying on really coming to an understanding of your tribe's culture and using that as a backbone to be able to think about how to proceed in the circle, what kinds of values you have to think about what kinds of solutions you might craft. You also have family-based values. So you've got the values of the tribe, and then under that, you may also have the values of the family who's involved in whatever conflict, or the people involved, individual people involved in the circle, even if they're not family. And then even one level below that, you may have certain values that you as a circle, as a particular individual single circle, want to operate with as well. And so again, within all of that, you're just always making sure consulting custom and tradition. And then there's always going to be a discussion of the issues. So there's an emphasis on problem solving and transformation. And here's where you will see this be very different than court, and really even different than like a mediation or some other kind of dispute resolution that's not in court, but that's also not peacemaking. So here we are going to talk about how to address the problem in front of us. We're going to talk about how to deal with the issue. but we're really going to focus on transformation, so becoming something more and better as we exit, healing, wellness, coming back together and closing the circle of things we talked about before. And this idea comes from a good friend, Cheryl Fairbanks, who I think just said this in a beautiful way, and it's something I've always taken with me and something I think is something that we can incorporate not just in a peacemaking circle, but really in our daily lives, is to be tough on the issue, but gentle on the person. So Cheryl says when there's a conflict or a difficulty between people, that the issue is the thing that we need to address, but the people, we need to make sure to be respectful and loving and caring and really honor them as individuals. So if you ever get a chance to meet Cheryl, she's super great. She's totally vibrant, lots of fun. You'll have a great time talking with her. And then you can ask her about this because it really is just a beautiful sentiment. Okay, so in peacemaking, who participates? We talked a little bit before. Again, in court, you're looking at the judge, maybe a lawyer for each side or a lawyer for the state, and then a person who's been accused. Even in something like a mediation, you're going to have a mediator and then the two parties in conflict and maybe representatives for each of them, possibly some support people. But again, we're looking at just a few people. So in peacemaking, we want to take a much more expansive view of who can participate. So we want the community involved. And by that, what we mean is we want to think about who the community is and who would be necessary for the circle. So the community isn't just me and the person I'm in conflict with and the peacemaker, but as we talked before about kind of generational participation, thinking about who in my family or who in my community would be really helpful in getting this problem done, not just me and the other person, but are there other people who know about the issue? Are there other people who we respect who we could rely on for good advice in the circle? So really taking an expansive view of community, getting as many people involved as possible, and that way you are involving more creative problem solvers, you're involving more cultural knowledge, and you're just getting a much better look at what would work for the community. Secondly, you want to have family involved, so more than just the two people involved. We've talked before about going up the ladder, so up to your grandparents or up to your aunts and uncles, and down the ladder, going down to your own children, and also going across the board, involving your own siblings. And of course, sometimes there are people who need to be involved in the circle who are just part of the larger process. So for instance, if you're looking at somebody who for any number of reasons has other outside resources that are coordinated in helping them, you might have social workers who would be involved. You might have court staff involved in it, different advocates. So you'll see, lawyers in some cases. You have guardians ad litem, CASAs. And even, you might even get some judges involved sometimes, which is just beautiful. That would never happen in a court in a normal Western tradition. You might have support players involved. So if we're talking about folks who have other people, again, other resources coordinated for them, counselors, whether that be drug and alcohol or any other number of kinds of counselors, therapists, things like that, different sponsors. Language interpreters, they might be involved in the process. Judges, if we're talking about kids, school officials, principals, teachers, guidance counselors, those kinds of people. So again, already we're talking about many more people than would be involved in a courtroom setting. And then, of course, the peacemakers. When I say may work in teams, all I mean is that oftentimes we will advocate for not just a single peacemaker in a circle, but a couple of them so that they can be a help for one another and also add more wisdom or guidance to the process. One of the things that makes peacemaking amazing is that you can come up with creative agreements. So just last night I was telling you I was teaching this really long class, and one of the things we talked about are what judges are able to do. In Western courts, judges can really just order people to pay money. They can issue an injunction, which just means they're telling somebody that they can't do something to stop doing something they're already doing, or they can't do something they said they're going to do, Or they can order something called specific performance, which is basically you promised to do something and now I'm going to make you do it. As most judges will tell you, really what they end up doing is just ordering money damages. Tribal courts have a lot more latitude because of the sovereignty, inherent sovereignty that tribes have. So they have some more latitude as to what judges can do. But even still, in a more collaborative process, in a peacemaking circle, you're looking at just a much, much larger universe of potential solutions. So things that can really be helpful to getting a problem addressed. And that includes thinking about the people who's involved, thinking about what their needs are, what their interests are, really looking at the root of some of the issues, the relational problems that may occur in some of these cases. So it really expands what peacemaking do, or peacemaking really expands what kinds of solutions you can come up with. In peacemaking, the participants are the people who make the decision. So you come using consensus, you come to a decision about what should be done as a group. So not just the peacemakers deciding you should do something and telling you and then you're abiding, but really as a whole big group coming to a consensus about what will be done. And the nice thing about coming to a decision together as a group is that then you get people who are much more willing to stick to the agreement, much more willing to do what's been asked of them. And you get other people who are willing to help along, check in on other people who are supposed to be doing certain things and really helping provide a support for them as well. So you end up with just significantly better compliance using peacemaking. You also have a greater range of types of agreements that you could have. You could absolutely have written agreements, and that often is what happens. But you can have customary agreements as well. So things that really rely on custom and tradition. So hearkening back to incorporating more of the tribe's real fabric into what the agreement looks like. Obviously not things we're going to have in a courtroom, for instance. And then the enforcement. You have a lot greater latitude for that as well. It could be through a judge's order, and sometimes, especially in court-connected peacemaking programs, that whatever gets issued is issued as a judge's order. You could use contempt power, so one of the ways that you can enforce is to say, well, if you don't enforce these, I have the power to bring you back into court or make you do certain things. But you also get community enforcement. You know, one of the advantages that some, especially smaller communities have, is that people know other people, and they have a sense of what they're supposed to be doing, and they have a sense of what's going on, and they know each other's grandmothers or aunties and uncles, and you can really kind of help look in on people and help make sure that they get the support they need as they're going through and trying to comply with an agreement. And finally, you have the option for doing some sort of monitoring, which is where you can talk through the idea of having regularly scheduled additional peacemaking circles to follow up, and then just the sort of normal monitoring procedures that you might see in any sort of process. Okay, so why is peacemaking better? Well, one, you can intervene a lot earlier. So oftentimes in normal courts, or I shouldn't say normal, Western courts, in Western courts, we don't see a problem. Even in tribal court, we don't see the problem until there's been some sort of something filed. And that's a problem because once something gets filed, it's in a system and you're in a process, and that really limits your options. However, here you can intervene a lot earlier. You could have non-court connected peacemaking programs where people have the opportunity to go and address a problem before it becomes really big, or get sort of preemptive help or preventive help on an issue that they either see coming down the road or they're starting to develop right then, but without initiating some sort of formal process that you're then sort of stuck in. You can also, in that early intervention, you can do preparation circles. So that might be just the peacemakers and just a couple of people, just the individuals involved, like individually, so one party and then later another party. So doing some preparation work with each of the individual people along the way, or involving smaller family units in some of that prep work so that you are really helping people have an understanding of what the process is going to be like, have an understanding of how they might participate as real productive participants in the process. So lots of things you can do there. And then, of course, one of the things that makes peacemaking really great is that there's just significantly more and better information sharing between the participants and the legal system or either the peacemaking program itself, because of the number of people involved, because of the level of stake that each person has in their involvement, and because of the agency that people are given, that you're just able to do a lot more information sharing and get things more open so that there are just better information to solve the problems. It also, peacemaking is better especially for tribal communities because it accounts for some of the circumstances. When you have smaller communities, people know one another. And when you have small communities, putting someone in jail may be a real problem. That may remove a big piece of someone from the community that someone relies on. So it's helpful to be able to think through who we are as communities, what the makeup of our communities are, and what makes them uniquely Indian or uniquely indigenous so that we can address problems that way. Also, in indigenous communities, you've got continuing relationships more so than in the Western world, which means we have to see one another on a daily basis at the diner or at the powwow, wherever it happens to be. We're going to encounter one another routinely and repeatedly. And so finding a way to address problems, especially as they relate to relationships, so that we can, when we're together in any sort of gathering or just passing one another on the streets while we're getting gas or whatever, that we can do that in a healthy and civil way, and in a way that builds the community up instead of tears it down. And of course, you've got the myth of anonymity in Indian country. Most of us know one another. Just today, Rebecca and I were talking for the first time and talking about the different people or different places we knew in common. So that's just something that we need to sort of be mindful of. One of the other reasons that peacemaking is great is because you get other entry points into the program. So there are checkpoints along the way if you have a person who is in treatment or going through some other court program, or even if you're talking about a juvenile where grades are coming out. These are all kind of natural checkpoints that might be a time to reconvene a circle or to just reassess the solutions that people are trying to follow. You get status hearings in court, and then just sort of normal, regular monitoring that goes on. So these are all things that help peacemaking be a more inclusive, a more expansive, a broader, just a more integrated process than a normal court process. So all those things that we were talking about before in the U.S. justice system, those goals, peacemaking accomplishes those. Peacemaking makes for better deterrence because it invests people more greatly in their community and more greatly in one another, and it takes the time to actually just remove their desire to create problems or to be involved in problems. Of course, because one of the major goals of peacemaking is to heal people, to transform them, to bring the community back to health and wellness, that accomplishes some of the goals of rehabilitation. And because we know our people better who are going through the process, we might also be able to just target solutions that are going to help them feel more honored and valued in the process so that they become a more full participant in the community. Okay, so I will say peacemaking is not very good at retribution, but that's okay. That's not something we're trying to be good at anyway. So to sort of pull this all together, to give you a comparison between a court process and a peacemaking process, I've put together a couple little charts here. You can find some of these, I think, in a Michigan bar article that Judge Tim Connors put together. He included these, and I thought I was really honored to have him include some of these. So when I'm talking about court here, I'm mostly talking about Western court, but some of this will apply to tribal courts as well. So as we talked about before, tribal court does have more leeway latitude in how it can do things because of the inherent sovereignty of tribes. But at the same time, as most of you probably know, when you see a court, one of the things that a judge in Michigan, Judge Petoskey of Pokagon, says is that the tribal court does look a lot like a white man's court, he called it. And it's this really beautiful story that he tells. And so because of that, some of what is here is going to apply to tribal court as well. So let's take a look at these. So who gets to participate in regular court? In Western court, we're looking at restricting who gets to participate, limiting really that to just the parties and the representatives. Though sometimes if court is public, some people can go to watch, but they don't get to participate. They're just observing. In peacemaking, we have much more open participation. The community, and you will get together as a group and decide what members of the community should be in attendance and should be participating. So people are going to get a voice. Anyone who's there is going to get an opportunity to help solve the problem. And we're talking about who the third party is, the neutral. In court, we're talking about a judge. That's really who we're talking about in court. And that person is 100% the decision maker. They get to say who goes, they get to say how it goes, and they get to impose the decision, often even level a penalty. Peacemaking is very different. You will have peacemakers who are there to be your process experts, but not there to be the people who decide how it's going to be. They're going to help you through the process, but the participants are all going to be equal. And so we're all going to get a voice. We're all going to get to participate. We're all going to get to come to that consensus together. What issues can be talked about in court? We're really talking about broken laws and civil liability. In peacemaking, you absolutely can talk about broken laws. You can absolutely talk about civil liabilities, but you get the added advantage of being able to talk about both community and interpersonal relationships as well. What about the focus? So in court, we're really focusing on past conduct. We're trying to assign blame, to see who did what, to see what individual neglected their responsibilities or was the person who was responsible for committing some act, and then what legal responsibilities they have so we can see how much blame to assign to them. Peacemaking is different. We are going to talk about the past, but when we talk about the past, we're going to talk about a much fuller version of the past. So not just this one event that we're trying to decide who is to blame for, but we're going to talk about our culture. We're going to talk about our ancestors. We're going to talk about the history that we've shared either as a family or a community or just two people who have a long friendship, whatever it happens to be. We're also going to talk about the present, so get a sense of what's going on now, but then really talk about what the future is going to look like as well. So one thing court does not do is provide any future remedy. They assign blame and punishment for the past, and then they move on. In peacemaking, you're talking about how are we going to behave as we move forward? How are we going to relate to one another as we move forward? How are we going to interact? What are we going to do to build ourselves up? So you get an individual who has some responsibility in that arena, but because of who we're involving and the approach that we're taking, you get community responsibility as well. So you serve the needs of not only the individual, but the community. What tools do we use? In court, we're really talking about incarceration. If we're talking about a criminal matter, we're talking about either restrictions or in like an injunction or something like that, or just making people pay money. But all of that happens through the power of the court. So it's coerced. It is something that you have to do because the power that the court holds. Peacemaking is different. The tools we're talking about there to help people along are really building trust, finding a way to build networks and communities of support, really trying to restore both individuals and communities to wellness, and thinking about, even in criminal matters, getting people back integrated into the community, because the fundamental theory is that we need these people involved. They matter, they have value, and the community is stronger when we're working together. In court, the procedure that you have are very fixed rules. There are good reasons for that. Those fixed rules are in place as designed for protections against abuses by the court. So there's a good reason the fixed rules are there, but they are fixed rules. In peacemaking, you're going to have much more flexibility to work with and design a process that works for people. And finally, what are the results? In court, you have a winner or a loser. And let me just say, in court, you mostly have losers, and here's what I mean by that. When two people are in conflict, if they've sued one another, for instance, or there was an assault or something like that. When a judge decides for someone, the person that the judge decides against is very unhappy. They walk out of court a loser. But you know what? Oftentimes the person that the judge decides in favor of is still unhappy because they don't think the punishment was harsh enough, or they don't think the other person had to pay enough of a penalty. And so they end up unhappy as well. So in peacemaking, the results should be very different because you have the latitude and, more importantly, the goal, the fundamental principle of finding common ground so that you can really address what everyone needs to come away with a solution that's both going to benefit and make everyone happy, or at least make it's something that people can honor as they move forward. Court is on public record. Peacemaking, so we're talking about confidentiality. In court, most of those proceedings are public, and so they'd be in public record. In a peacemaking program, you'd be looking at confidentiality as something we're very much trying to honor, but thinking about the exceptions that come along. So there may be some mandatory reporting issues for things like child abuse or other kinds of domestic abuse, for instance. So you may have some mandatory reporting issues, and you also just have to kind of deal with the understanding that there may be confidentiality may be hard to 100% enforce just because of the relationships that people have with one another. Also, finally, the decision making. In court, you're talking about adversarial decision making. It's one person versus another person, or either the state versus the individual. And in any event, it's two people, two parties head-to-head looking for a winner and a loser. And the decision that comes is imposed by the judge. Whereas in peacemaking, you're talking about really building a consensus among the people who are in the circle, thinking more broadly about how that affects the whole community, and thinking one step even more broadly than that about how that affects not just the whole tribe, but the whole ancestry, the whole custom, the tradition, who we have been as people moving forward to now. Okay, so that takes us to, I think we have hit our spot where we can do questions and answers, and I'm happy to stay on as long as you need.
All right, so if folks would like to type questions into the chat box, or if you're participating via telephone and you'd like to raise your hand so you can ask your question out loud, please do so now.
I think I see someone typing, so I'll wait till that comes in and then we can talk about it. Oh, it's Chris. Oh, that's wonderful. Chris, how are you? Chris is here in Kansas as well, and he's been a really helpful supporter, so I'm happy to see him here. This is great. Okay, so the question was, stress and confidentiality, what do you suggest you do with the mandatory reporting issue? It's quite a bind because your tribe almost certainly has, especially in matters of child welfare, that sort of thing, almost certainly has mandatory reporting statutes within your tribal code or somewhere. So one of the things that you ought to do is when your peacemakers are explaining the process, one of the things they're going to do is talk about the idea of confidentiality. And just to make sure it's clear to everyone, you have to be able to relay to people what the exceptions to confidentiality are. So you should just say, if we hear about child abuse or whatever it happens to be, whatever your mandatory reporting requires, just tell them if that comes up, just understand we are obligated by law to report that. And that way everyone understands at the outset and aren't surprised in the end when you end up reporting them for something they didn't suspect you would. Because the last thing you want them to do is lose faith in the process because you blindside them with violating their confidentiality when they expected to have kind of full anonymity or whatever. So I think always letting people know the exceptions in advance is the best way to go. It's just the best practice. I see a couple of people are typing. I wish I could sing or something. I would entertain you guys while we're waiting for the questions to come in. Unfortunately, that would almost certainly ruin your day, so I won't do that. So it says, what advice do you give when judges or peacemakers lack hope that the interventions with alcohol abuse will be successful? So I will say I do not know a lot about substance and alcohol abuse, and so I would hesitate to give you any sort of advice that might make it sound like I'm an expert in the area, because I certainly am not. But I would say, I guess, if you've got people who are judges, peacemakers, if they're not sure it can be successful, there's part of the process, and they may be totally right, but there's part of the process that still has value for the people going through it. It may provide some sort of hope or support or even kind of a therapeutic or cathartic value to the other people who are in the circle, even if they're not the people who are having the alcohol or the drug issue. Just getting to be there and being a part of the process, getting to address their concerns and their worries and their hopes and all that sort of thing for the person who is having the alcohol or drug issue can bring a lot of value to them. And even if the person isn't ready to be in a place where she can begin to heal, go through the steps of taking on the long road of healing herself from that, having seen so many people there who can be a support, who have such faith or hope or love, or even just seeing their disappointments, so those things have value. So even if we don't think the process will solve the problem, going through it may have value that we don't see immediately, but has value down the road. I'm sorry I'm not more of an expert there, and I apologize for that. So Chris says, we haven't run across this. I will keep you in mind, though. We're doing well. Okay, sorry, I won't read that. That's not a question. Thank you, Chris. Another question, would it be possible or feasible to implement this holistic approach in the U.S. court system, or is the adversarial nature of the U.S. court system too difficult to work around? So I got to tell you, before I met Tim Connors, I would have said no. So Tim Connors is a judge in Michigan. I would have said we couldn't possibly implement this in a Western court. He's a judge in Michigan, in Washtenaw County, which is, I'm not super familiar with geography, but I know where University of Michigan is, and that's that county. So he is a state court judge there, and he has, with consulting with lots of different other people who are peacemakers and understand the process, has gotten both permission to and guidance on implementing this in a good way in his court system to really fantastic success. So I'm honored to know him, frankly, because I think if you had asked me this question a little while ago, just a few years ago, I would have said no, but he has proven that I was wrong to think that. And he's so generous in sharing his wisdom and how he's doing things and the way he approaches things that he's a good person to ask for something like that. So I think it is possible, and how we would do it, how we would roll it out kind of nationwide, I have no idea how to approach that yet. But man, Judge Connor sure has given us a little bit of a blueprint, at least how to roll it out in a singular court system. Any more questions coming in? Oh, here we go. Here's a typer. Oh, you're welcome. Absolutely. I'm happy to to share whatever I know and frankly try to tell you when I don't know something.
Oh, you have an invitation to go to Alaska.
Oh my God, I've only ever been to Anchorage, and I was just awestruck the whole time. So I will gladly come to Alaska whenever the invitation is open. It is beautiful, and I'm sure I saw the least beautiful part of Alaska, so I'd love to see even more.
All right, any final questions? Rebecca, I'm going to turn it over to you to close us out.
All right, sounds good. Thank you, Sean, for that very interesting and informative presentation. Before we conclude, I just wanted to take a moment to talk about NYJA and our work in tribal communities. For those of you who are new to our webinars, NYJA is a tribal justice professional organization whose goal is to build and enhance tribal court capacity. We do a very broad range of work for our tribal communities, including training and technical assistance to support tribal courts. We're also TA providers for the Bureau of Justice Assistance CTAS Purpose Area 3 grantees. Another part of our work is the Tribal Access to Justice Innovation website. This website allows us to highlight and share different programs in tribal communities. If you know of a promising program, let us know about it. And if it's not already highlighted on the website, we can go ahead and share it. That website is tribaljustice.org. And again, our goal with it is to learn about emerging practices and share that information as many tribes are addressing common challenges. So with that, we'll conclude our webinar. My email address is Rebecca, REBEKAH @NYJA.org. If anyone has any questions or TTA requests. Otherwise, thank you to our presenter for your presentation and NCJ FCJ for hosting. And thank you everyone for joining us today. Jessica?
Thanks, Rebecca. And I just want to let everybody know that we're going to have an evaluation that hopefully will pop up on your screen. Let us know what you liked about today's webinar and any topics